Regular calendar. House bills on third reading. House Bill 1554, a bill relating to the Property Owners Association Act, amendment of declaration. Reported from the Committee on General Laws and Technology, and there is a floor amendment.
The senator from Eastern Fairfax County, Senator Surville.
Mr. President, even though I think making a motion to waive reading of the floor amendment will take longer than it will to read it, I waive reading of the floor amendment.
Thank you, Senator. The question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The reading of the floor amendment is waived. The senator from Eastern Fairfax County.
Thank you, Mr. President. I move the floor amendment. Speaking to that motion.
Senator has the floor.
Thank you, Mr. President. Ladies and gentlemen, this bill has to do with homeowners associations, and basically the legislation is a response to a Supreme Court case. It basically reverses a Supreme Court case called Tvardik versus Powhatan Village Homeowners Association out of Williamsburg and James City County Circuit Court. I thought it was a rather well-written opinion by Justice Arthur Kelsey, and I usually don't agree with much what Justice Kelsey said, but I did this time. And this bill basically nukes his entire opinion. So the bill before you does two things. Even if this floor amendment is adopted, I'm still going to violate Mr. Jefferson's principle and vote against the entire bill. I want to make that known ahead of time. But with regard to the issue I want to focus on right now, to break this bill into two pieces, the way a homeowners association works is when you buy a home in a homeowners association, it's subject to what are called covenants or a declaration. That's a contract between all the homeowners in that neighborhood. And typically those covenants say they can only be amended by a supermajority vote. There's some out there that say majority. Most say 66%. Some even go as high as 80%. And that document is sort of like the Constitution for your homeowners association. And it's a very important document because homeowners associations, basically, you give away your property rights when you join one of these. When you buy a home in one of these, you give away your property rights. And homeowners associations have frequently been trying to get these amended because they would like to get more power. They would like to make them, they'd like to change them, especially in the older associations. What Tvardik said was, if you read the code, what the code says is that if the homeowners association tries to change the Constitution, the covenants for that association, you have 1 year to challenge it after it becomes effective. And Justice Kelsey read through that and said, well, effective means that's when the homeowners association jumped through all the different hoops they have to jump through to change the rules. And one of the rules that we, the General Assembly, placed on them back in 1999 was that you can only change these documents by having every homeowner sign a piece of paper saying, I agree to change the Constitution for my homeowners association. A raising of the hands isn't sufficient because this is such an important decision you're making. You have to get signatures. And in that case, the homeowners association didn't get signatures. And so Kelsey said it was never effective, and so you could challenge it for more than a year. You could challenge it for 5 years, 10 years, 15 years. If the HOA didn't follow the rules, you could always challenge the declaration. By changing it to recorded, which is what this bill would do, what you do is you basically immunize the homeowners association for breaking the law. So basically a homeowners association could break the rules in terms of how they change their constitution between homeowners, file that piece of paper with land records, and a homeowner could only fight that for 1 year, even if the law was broken, even if the rules were broken, even if the process was broken. And from my perspective, Mr. President, that's wrong. You got to remember that many of these HOAs can be pretty small. Some of them can be as small as like 5 or 10 houses. They're not professionally run. They're run by volunteers. And I have seen them intentionally break rules. I've seen them do things behind closed doors. I've seen them violate all kinds of rules. And basically what this does, it allows HOA boards to immunize themselves. They could say, we took a vote to change these. The president could sign off a document, stick it in land records, and you'd be barred from forever challenging it if you don't figure it out for 1 year. Because I'm sure all of you have looked at the land records for your property in the last year to see what anybody's recorded against your home. I'm sure you all have, right? So basically, this just keeps the law the way it is. From my perspective, it's worked fine. The homeowners association industry doesn't like the Tvardik decision. They thought Justice Kelsey was wrong. All he said was, I'm reading the law you guys wrote, and I think we ought to keep it the way it is. And I think that taking that out of this bill will make it a little bit better. It won't make it great, but it'll make it a little bit better. I would hope we adopt the floor amendment.
Thank you, Senator. The senator from Stafford, Senator Stewart.
Thank you, Mr. President. Speaking to the motion.
The senator has the floor.
Mr. President, I too must admit I'm going to vote against this bill either way, but this does make it a little better. The gentleman from Fairfax is exactly right. You literally could change the covenants, violate people's private property rights, record that, and you wouldn't have a cause of action to fix it. There'd be no way to fix it. So I hope this makes it a little more palatable, even though it's a horrible bill to start with. It's just a little bit better, so I hope y'all will support the amendment.
Thank you, Senator. The senator from Mecklenburg, Senator Ruff.
Thank you, Mr. President. And speaking to the amendment, I would recommend that the amendment be rejected. This amendment would make it less clear as to when a court challenge could be made.
Thank you, Senator. The question is, shall the floor amendment be agreed to? All in favor of the motion will say aye. Aye. Those opposed, no. No. The ayes have it. The floor amendment is agreed to. The senator from Fauquier County. 2, 3. The senator from Mecklenburg, Senator Ruff. They're going up and down faster than I can count them.
Thank you, Mr. President. I think that the gentleman from Eastern Fairfax probably described the bill pretty well. I would also say that the bill simply makes the I'd move that the bill does pass. The bill simply makes the Virginia Property Owners Association Act consistent with the Virginia Condominium Act on certifying amendments. Without the legislation, it could void all prior changes that had been previously made, and voting no puts this into question the validity of hundreds of declarations that have been amended in accordance with their requirements. I renew my motion.
Thank you, Senator. The senator from Franklin County, Senator Stanley.
Thank you, Mr. President. I rise to speak against this bill.
The senator has the floor.
Thank you, Mr. President. You know, the senator from Eastern Fairfax is exactly correct. You know, we have one of the most sacred things called property ownership. And the history of the homeowners associations, POAs, HOAs, however you want to call them, are that they are government created. And really the history, Mr. President, members of this body, of this government creation of a basically quasi-local government is that otherwise a lot of these larger neighborhoods might create towns and cities. And so in order to avoid that, you allow these homeowners associations to kind of come together. But in doing so, it changes the whole context of your property and your rights within that to use your property. And you subject yourself, when you buy a house, to a homeowners association. Part of that transaction is they give you the packet and say, do you agree to these rules? And if you do, you can move forward with the closing. If you don't, you can leave. You can reject the contract, not lose your deposit or anything, because these are rules that run with the land, as we say in the law. They run with your title in your deed. And so when you set up these little governments, they have this incredible power then to change even after you've signed on or agreed to what was existing in your property and in the calls of in the running with your deed. They can change it again. So I'm reminded some of the best majority opinion writing I've read on these property owners and homeowners association is found in the Tavares case. Stephen Tavares versus Powhatan Village Homeowners Association. 2016, just happened, just released 1 year ago. In that, the majority wrote, Code Section 55-515.1F is conspicuously precise. Written by the General Assembly, Mr. President. It requires the certification to verify that the requisite majority signed the amendment or ratifications thereof. There is a difference between adopting an amendment and signing it or some written ratification of it. In theory, a requisite majority could simply make a show of hands at an association meeting and thereby adopt an amendment. This code section, however, demands the extra precaution of requiring that the members voting in favor of the amendment verify that vote with their signatures. So no doubt as to discourage quarrelsome disputes between neighbors about who voted for what and when. Powerful words, Mr. President, but he goes on in the conclusion, which I think is most important for us. Remember, the General Assembly created these homeowners associations, Mr. President, and they did so with precision, as is stated in this opinion. Justice Kelsey says the Virginia Property Owners Association Act authorizes the creation and enforcement of restrictive covenants against non-consenting landowners in a manner unknown to the common law. The General Assembly, us, however, police the imposition of these covenants with a host of strict procedural requirements, not the least of which is the plainly worded command that no recorded amendment, and recorded in the land records he means, shall be effective unless it is accompanied by a certification verifying that the requisite majority sign the amendment or a ratification of it in accordance with this code section that they are now trying to change to make it easier for them to change the rules by which they subjected themselves and are created by, Mr. President. Judge Kelsey finishes, in effect, the General Assembly created something entirely new to the law. That is, the right to form private associations having power over land use and ownership, while adding precautions to honor the common law's ancient antipathy towards restrictions on the free use of private property. There is a reason why this is here. There is a reason why it should be here. And there is a reason why it should stay here. You are opening the door to allow a certain few in your neighborhood change your ability to use and enjoy your real estate, your property. That, ladies and gentlemen, because every speech that I have has this in it, is un-American. And I urge this body to vote this down. Let us take carefully consideration. Let the Housing Commission or something else. Let's work on this. Let's not give the few the power to do that which they want to your property. And I thank you, Mr. President.
Thank you, Senator. The senator from James City County, Senator Norman.
Mr. President, I rise in support of the bill as amended, in spite of the inference that it is un-American. But I guess with all of the homeowners association that have saturated Franklin County, this has become quite an issue down there on it. Mr. President, a couple of thoughts. First of all, I concur that the General Assembly absolutely did create this law. And consequently, because we did create it, we retained the inherent authority to amend it when we find that there's some frailties, or, as I have heard on the floor of the Senate on more than one occasion, perhaps when the courts don't get it exactly right and we need to provide that legislative guidance to them. And so I would say there's nothing inherently wrong with trying to amend this. First of all, the bill does bring into conformity what most of the homeowners associations have felt has been the law for many years. And this is not something that is insidious to a homeowners when they purchase. The senator was absolutely right. There's mandatory provisions under the law that every homeowner receive a disclosure package, and they have an absolute period of time where they can rescind or back out of the agreement if they don't like it. And one of the things that homeowners association do, and I know that many of us in this body live in communities that have homeowners association. I bet some even in East Beach if I was to look into it. And it is a mini form of government, and the purpose of those homeowners association is not to strip or abrogate the personal property rights that an individual may have, but in fact to protect the property rights of the entire community. And those homeowners associations, of course, governed by a board of directors that are elected very similar in a fashion that those of us on this body are. And I suggest to you that I don't believe there is anything un-American about this. I don't believe that there is anything insidious about it. And I don't believe that, in fact, it is depriving anyone of the property rights that they have, but it's trying to bring in conformity and make sure that the homeowners association do have the right to continue to protect those property rights and that which is attendant to it. So I suggest that it is the American way to vote for this bill.
Thank you, Senator. The senator from Stafford, Senator Stewart.
Thank you, Mr. President. I rise to join with the gentleman from Franklin on this issue. And I'll tell you, when you buy in these associations, you have restricted covenants. You know what you're going to be subjected to. You know what you can do with your property, with your house, with your lot. And the General Assembly years ago made it hard to change those. And that's the way we want it to be. We want it to be hard to change those restrictions. And so, regardless of what we've all heard about what this bill does, at this point, here's what this bill does. If you actually read line 42, I would tell you that it doesn't call into question the validity of changes that may have been made by HOAs prior to 2017. What this bill would do now is validate every change made by an HOA prior to 2017, even if they broke the law and abrogated your rights as a property owner. You as a property owner have no ability to go back and challenge that to get it fixed. So that's what this bill really does now. We don't do that as a General Assembly as far as I know. We don't go back and say 100 people broke the law over the past 20 years prior to 2017, but we're going to validate what you did and say it's okay without even know what you did, what you did to do that. And I'm sorry, victim, if you're victimized, you're just out of luck. That's what this bill does, and I think it's the first time I've really ever seen us take an action like that. I would hope we'd vote no on this bill.
Thank you, Senator. The senator from Northern Chesapeake, Senator Spruill.
Thank you, Mr. President. Mr. President, I'm trying to make the bill. Anyone speak on this bill? A question to anyone? Senator Norman, please.
Would the senator from James City County yield a question?
With some reluctance.
He's yielding, Senator.
I'm trying to find out, hearing what you're saying, and I'm really against homeowners. Is this bill directed to a certain part of the state? I know we have two states. We have Northern Virginia, which is another state, and we in Virginia. So I'm trying to find out, is this bill just for one part of the state? Is it for everybody?
Senator from James City County.
Mr. President, I must confess, I don't know how to answer that question.
Well, Mr. President, I'm knowing who put the bill in, and I know certain parts of the state sometimes have a problem, and they're trying to rectify the problem in that part of the state. So I'm trying to find out, Delegate Bullover put the bill in for North Virginia. So I'm trying to find out that if they have a problem in that part of the state, are they trying to fix something in that part of the state and make it mandatory for the whole state?
Thank you, Mr. President. I would say that even though this bill came out of an extraordinarily important jurisdiction, it is not a parochial bill that is trying to fix a particular situation in any one locality. It, in fact, is addressing a statewide situation. It just happened to be that the case that went to the Supreme Court happened to come out of my backyard, and unfortunately, I'm not sure the court got it right.
Thank you, Senator. Thank you, Senator. The junior senator from Loudoun, Senator Wexton.
Thank you, Mr. President. Speaking briefly to the bill, Mr. President, ladies and gentlemen of the Senate, and I hesitate to speak to this because I am far from a big fan of the fourth level of government here, but I do think it's important that we understand exactly what this bill does and kind of how it came to be. This originally, the subsections D and F were introduced, I guess, by my predecessor, who is now serving on the Supreme Court of Virginia, to address those situations where the declaration did not include a way to amend the declaration subsequent. And so that is how we came up with this 2/3 requirement. And it is true that subsection D talks about a 2/3 vote of the owners. And that could be a show of hands. But you can't stop reading the bill there because that's only one part of the process. The rest of the process involves the requisite majority of lot owners executing the amendment. In other words, they all have to sign off on it before it is recorded. This Vardek decision that we keep talking about didn't say that that process wasn't followed. In fact, that was really a case where it was reversed on a technicality, which it truly was, because in the certification that was filed with the land records, it indicated only that it had been approved by the 2/3 majority of lot owners, instead of signed by or executed by. So it was truly just a technicality. I believe that with the floor amendment that the senator from Eastern Fairfax has put on the bill, we're not going to be grandfathering in all of those declarations that were amended in a faulty manner. So there is still a cause of action for them, because those declarations are not effective. But I think that as we move forward, it's important that we recognize what this bill actually does.
Thank you, Senator. The senior senator from Chesapeake, Senator Cosgrove.
Thank you, Mr. Chairman. I'll be very brief. Ladies and gentlemen of the Senate, be very careful with this bill, because homeowners associations can create great mischief. Most people think their homeowners association is a, quote, civic league. Oh, do I need to go to the meeting? Oh, no, it's just a civic league thing. And it's not. These people have great authority over your property. I live in an area with a homeowners association, and I have some experience with dealing with the homeowners association that has not been responsive, that has not been effective, and has not been transparent. Now, I think this bill is well-intentioned, but you want to talk about un-American, there's a homeowners association in Northern Virginia won't let you fly an American flag. Now that, I would tell the gentleman from James City County, is un-American. Thank you, Mr. President.
Thank you, Senator. The junior senator from Virginia Beach, Senator DeSteffe.
Mr. President, I'm not an attorney, and I didn't sleep at a Holiday Inn last night. But I'll tell you that for the basic premise of this bill is, imagine that you move into a community with a homeowners association. It tells you what you need to do in the documents on how to appeal or change something. It's pretty simple. What the Supreme Court decision did away with all of that and says, oh, that's not how you're going to do it. Now you're going to have to throw out the way it said before, and here's what you're going to have to do. You've got to only approve it this way. So basically what it does is it creates confusion in the whole process. When you have confusion like that, what happens? Well, that's where your homeowners association attorneys get involved and make a lot of money with this confusion that we're creating. So if you support this bill, then you should vote for it. If you want to create confusion and make our homeowners association attorneys very wealthy, then you should vote against the bill. Thank you very much.
Thank you, Senator. The senator from Alexandria, Senator Eben.
Just speaking briefly in favor of the bill.
The senator has the floor.
I think the bill is clarifying and creates less lawyering. If the homeowners association documents are silent, then 66% of the people in writing can get them. 67%, I'm told, by counsel, can get it amended when it's silent otherwise. If you want to make a change, there's no other way to change those documents. So let's make it easier and clarify this.
Thank you, Senator. The senator from Rockingham, Senator Obenshain.
Mr. President, just very briefly, I want to clarify and maybe correct one statement that's been made. This does not override the documents. It doesn't. This only operates when the documents are silent. So if the documents are silent on the issue, the statute is going to be here for the sole purpose of providing an avenue for making an amendment. It does not change the organizational documents.
Thank you, Senator. The senator from Eastern Fairfax County, Senator Surville.
Speaking to the bill.
The senator has the floor.
Mr. President, I would say that not only is this bill un-American, but I noticed that sitting on our desk is not an American flag. It's a Virginia flag. And I think this bill is un-Virginian. Virginia, folks, is one of the places where we protect property rights. And I will tell you, these HOAs, just so you have an understanding of the amount of power they have. I was Googling around for some horror stories. A veteran amputee in Georgia had a lien placed to his home because of a trash can. A North Carolina man fined because he planted pansies in a common area trying to spruce it up. In California, somebody fined $25 a day for putting a divisive Christmas wreath on their front door. In Texas, an HOA, somebody built a white picket fence to protect their 6-year-old autistic son, and when the HOA didn't respond to their request, for 60 days they put it up, then the HOA fined them. In Arizona, a man was fined for putting his pickup truck in his driveway. The court ended up awarding him $187,000 of attorney's fees to vindicate his rights because his HOA had no business to tell him he couldn't put his pickup truck in his driveway. In Texas, an Iraqi serviceman lost his home to foreclosure for not paying $800 in fees while he was flying to Iraq. Louisiana, family sued by their HOA for putting a small sign in their yard honoring their Marine son. While in other homes, they had up signs for professions, schools, motorcycle rides, all kinds of things. But putting up a sign for your son who's a Marine ain't right because it didn't fit their rules. Chesterfield, Virginia, 3,800 homes were ordered to put a $155 identical mailbox on their property. When they all stood up and decided to paint it yellow, they all got fined by their HOA. There's a man that went to jail for not sodding his lawn. I can give you more and more. If anybody wants the whole list, I got a 20-page printout here of HOA horror stories. That's what these things can do if you empower them to do it. Now, I'll point out, this is an $85 billion industry, folks. 1 in 5 Americans now lives in these things. If you want to buy a new house, there's probably about an 80% chance your home is going to be in an HOA. You don't have a choice about whether or not to live in one if you're moving into a new house. If we leave the law the way it is, we make sure that if you want to take somebody's property rights, you have to get somebody's signature on the document before you do it. That overrides their documents if we leave the law the way it is. If we vote red, we will override those documents, and you have to put that signature before it's effective, and I think we ought to do it. People are unhappy with HOAs. I have a survey that was done by the Coalition for Community Housing Policy in the Public Interest. People who live in HOAs, 84% think the biggest problem is lack of transparency, 76% lack of involvement, 76% unhappy about the power to fine, 68% inconsistent applications of rules. These guys are out of control. They're not professionally run. They mess with people, folks. And from my perspective, we shouldn't continue to feed the beast here. We need to vote this bill down. This bill needs to go to the Housing Commission where it can be properly studied because it affects probably millions of homes in Virginia, literally millions. It ought to be properly studied before it comes here to be voted on, and it's not ready for prime time.
Thank you, Senator. The senator from Alexandria.
Would the senator from James City County yield for a question or two?
He's thinking about it, Senator.
Yes, sir.
I would ask the esteemed senator and the esteemed attorney to help me in understanding the bill. Does this bill, in effect, mean that if a homeowners association in its original documents has a rule against flagpoles, but I wanted to change them and it's silent, that with a 2/3 vote, I could allow for the American flag to be flown in that homeowners association?
The senator from James City County.
Mr. President, I don't know how to answer that question because there are some underlying constitutional issues about it, and I know that the flag has been waved from everywhere from Franklin County to Fairfax today on that. But the homeowners association spell out the declarations on what is permitted and not permitted. And it would depend, I think, upon the individual homeowners association and what is allowed or not is allowed. I would say in the community that I live in that a homeowner would not have the authority under the existing declarations at the time that I bought to put a flagpole up with any flag on it.
Thank you, Senator.
Briefly, final comment on the bill, sir.
Yes, thank you, Senator.
From reading the bill, I don't think it is full of homeowner horror stories. What it says is that if there's no way to change the documents with a 2/3 vote, you can. I don't think this is about taking power away from people. It's about giving 2/3 of them. If there's no other way, when I bought in a condo, and I have before, if I don't look closely enough between the lines, I assume that it can be changed, but I assume it isn't easily changed. So this allows it merely to be changed with a 2/3 majority. It's a simple bill. It's not a crazy, outrageous encroachment on the people who live in these associations. With that, I hope we'll vote yes.
Thank you, Senator. The senator from Stafford.
Thank you, Mr. President. Nobody wishes to speak again. Mr. President, I think it's important that everybody be clear. The law currently states today that you can change this with a 2/3 majority. That's what the law is in Virginia. That's what the Supreme Court case actually said. This is trying to change that. Now, it's been ameliorated somewhat by the gentleman from Fairfax's amendment. But put it a different way to the senator from Alexandria. If you bought in an HOA and you were allowed to fly the American flag in your yard, and they changed that provision and they did it unlawfully, if you vote for this bill, you would never be able to challenge that because this would validate that unlawful amendment. I'd hope you vote red.
Thank you, Senator. The question is, shall House Bill 1554 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their votes? The clerk will close the roll.
Ayes 23, noes 17.
Ayes 23, noes 17. The bill passes.